The Nigerian government has withdrawn the money laundering charges preferred against Tigran Gambaryan, an executive of Binance Holdings Limited. Gambaryan, facing money laundering charges totaling about $35 million brought against him by the Economic and Financial Crimes Commission, was discharged on health grounds and due to diplomatic pressure. EFCC's counsel R.U. Adada informed Justice Emeka Nwite during proceedings of the federal government's decision to withdraw the charges against the detained crypto executive. She, however, did note that the federal government would continue with the charges against the crypto company, that is Binance Holdings Limited. This morning, Professor Iwa Salami, a director, Center of FinTech, University of East London, joins me to talk about this. Thank you so much, Professor Salami, for joining us.
Thank you for having me.
Yeah, so I've been following the story since when it broke, and one question that kept popping up from all quarters was that what was the fuss all about then? What was the point of the show the Nigerian government put up, having to eventually, free the Binance executive when there have been months of accusations of a money laundering charge leveled against him and Binance itself?
Well, thank you for the question. Well, the situation, of course, we know started out as a result of obviously Nigeria being a very large market for crypto assets, and Binance wanting for that to continue and not wanting that to impact on their business. And as a result, they had invited, and as a result, Binance officials felt the need to actually meet with regulators in Nigeria, because of course prior to now there had been the situation where certain transactions had been suspended for certain crypto asset exchanges, including Binance. And so the rationale really was that these talks would be had with the Nigerian regulatory authorities and potentially, have a situation where they could resume their services in the country. But unfortunately, what happened was these two officials got detained. One, of course, escaped, and Tigran was the one that was left behind, if you like, to face the charges. Well, I suppose the issue around what the whole fuss was about, I suppose, is what everybody is asking, that when they came in for these meetings, the idea really wasn't for them to come and face questions, but to have kind of talks with the regulatory authorities. But then the authorities had said that whilst the conversations were being had, it became clear that violations against money laundering, anti-money laundering provisions had been breached, and tax evasion had occurred, and therefore they used this as a mechanism to detain them. But I think the fundamental issue really has been, was there any particular offense committed by the two officials, and particularly in this case, Tigran?
Yes.
And to be honest, it's been found that there was a legal basis to detain him.
Exactly. So that's where the bone of contention is, and the confusion, has been centered around since yesterday when this latest development came out. Now we're looking at Gambaryan, who was said now to be facing money laundering charges, $35 million, inclusive with the complicity of Binance itself. Now, the Financial Action Task Force has been on Nigeria's case for a while when it comes to money laundering and terrorism finance, and Nigeria is still on the grey list. So with this playing out, what implication do you think that will have for Nigeria, unless, just as you have said, there's actually no case here in terms of the person being accused?
Okay. So the Financial Action Task Force, of course, is the global standard setter to ensure that we have, financial stability that's not impacted by, financial crime, things like terrorism financing, and the proliferation of the financing of weapons of mass destruction, such things like that. And their fundamental priority is to ensure that we avoid financial crime through money laundering. And if we look specifically at crypto assets, part of their recommendations have introduced things like the travel rule for crypto asset exchanges. And fundamentally, what this basically means is that we need proper identification of parties that are transacting beyond a certain amount from one exchange, cryptocurrency exchange or crypto asset exchange, to another. Now, a lot of countries actually haven't particularly implemented what you could say the regulatory technology that can help ensure that the travel rules are complied with effectively. Nigeria happens to be one of them. And so for the FATF, the Financial Action Task Force, the importance for countries to actually bring on board the recommendations here to actually cater for knowing who is transacting and getting them to actually identify the various parties that are transacting, i.e., parties that are sending funds from one exchange to the exchange that's receiving it, to know the parties that are fully identified and fulfilling those transactions is quite critical for them.
So,
And what they've said, though, particularly as it relates to crypto asset exchanges, since that's fundamentally what we're talking about here, is that there's a need that, countries, and including Nigeria, adopt that. Adopt a regulatory technology framework for this. But I have to say that if we look at the progress that's happening with respect to crypto assets regulation in Nigeria, there's a lot of forward movement and a lot of positive
okay.
movement that's happening, and a lot of I'd say good progress that's been taken on board by the Securities and Exchange Commission, who have not just only established this framework for regulating crypto assets, which cover, for example, the licensing of crypto asset exchanges, and also sort of checking that those exchanges operate effectively, the licensing of activities done by crypto asset custodians,
Okay.
and also ensuring that for these, they actually do comply as well with AML, i.e. anti-money laundering, and KYC, know your customer requirements. And the Securities and Exchange Commission actually have done a brilliant job, I'd say, in trying to ensure that in order to be able to effectively license these exchanges, that they actually take them through what is known as the Accelerated Regulatory Incubation Program. And to be honest, we're seeing some progress there.
Okay.
So there, as we speak now, there are two licenses in principle, or approval for licenses in principle, have been granted to
All right.
exchanges.
Okay.
And this is particularly forward movements. Well, I'll allow you to ask your next question.
Well, I understand. Well, but then you agree with me that there is no system that is perfect, because there will be some who will intentionally want to circumvent our regulations and stipulated laws for, personal gains and all that. Now, we're looking at a situation whereby this person in question has been discharged on health grounds for of course, due to diplomatic pressure, he's been told to go and treat himself, basically. Now, when we look at the issue around regulations, monitoring the activities of the cryptoverse, the holders or the platforms in question, would you say that in this particular case, due diligence was not done, especially when it comes to the circumvention of the laws guiding the activities in terms of this course of investigation? Because Gambaryan was incarcerated for months, and Nigeria is saying it wants to tackle corruption, but then we'll see a country that seems to be bowing to domestic and international pressure. So when we continue to see this, and we continue to see the possibility of a country that is trying to fight corruption having these internal or external influences serve as an inhibition, how do you think that that platform or that cryptoverse or ecosystem will grow?
So there are two things here I think we need to clarify. And the first really is that, really, was there a criminal action that had happened, had Tigran, since he was the one that remained, conducted a criminal activity through money laundering directly? Okay, and I think that needs to be highlighted clearly. And then, of course, there's the second issue as to the tackling of corruption in Nigeria across the board, whether it's to crypto asset exchanges occurring in Nigeria or in other parts of the economy, indeed, whether it's in the public sector, private sector, in other dimensions. So taking the first issue, the situation really is that personally, Tigran could not have been said to have committed a crime of money laundering directly. The action was brought against
Binance.
Binance, who denies it. Okay. And I think this is where the bone of contention had been, that he had really no case to answer personally, individually. In his capacity as a compliance official in Binance, the question would have been for him to have been personally liable if he conducted personally any activities that warranted that, such as maybe, for example, personal fraud perpetuated, or if he acted beyond his powers that have been outlined in obviously the articles of association of Binance, for example, in which case he could be personally liable. But none of that had occurred. And which has been the question around, what the ground was for holding him and detaining him.
Okay.
Now that's, as I said, totally separate from, other cases of corruption that Nigeria actually needs to effectively look at.
Yeah.
Yes, there was a situation that, potentially the EFCC wanted to make it clear that actually anybody who engages in crypto asset activities in a way that's maybe fraudulent will be brought to justice and will be brought under the remit of the law. They could have been used as a scapegoat, if you like, in this case. But I think when it comes down to it, obviously, there have been pressures from the United States, pressures really questioning whether there was a misfeasance here, a criminal activity actually conducted that would have given the Nigerian authorities the position, or given them the wherewithal to actually detain him, and none was found.
Okay, so Professor Salami, in all of this conversation, the FCC is again at the center of another, if I could call it, botched graft war. We had one with the floating case around the former governor of Kogi State, and now we're talking about Binance, and it seems as though before this case can be put to bed, probably might take a longer period, looking at the scenario playing out now. Now, you talked about inhibitions when it comes to tracking and monitoring the activities within the crypto space and within the ambit of the issue around investigating situations like this. Would you call for the overhaul of the EFCC as an agency? Would you say there should be more liberalization of its powers to actually monitor and look at all the intricacies when it comes to crypto activities, or probably a rejigging, some sort of, looking at how these can be modified to enhance its operation? How do we strengthen the agency, as it were?
So personally, I'm not sure it's the EFCC's role to actually try to implement or enforce regulation against crypto asset exchanges, or indeed against market participants. This is primarily the role of the Securities and Exchange Commission, which is the regulatory authority that's designed to actually ensure that regulation is being complied with by market players. So it is the Securities and Exchange Commission that would be responsible for ensuring that crypto asset firms, virtual asset service providers, are properly licensed, that they're properly conducting themselves in a way that doesn't impact on investors, in a way that preserves investor protection, and in a way that facilitates financial integrity within the markets. This is the function of the Securities and Exchange Commission, and I dare say that I think the Securities and Exchange Commission, under this recent leadership, really understand that and have taken actions to doing that. With the EFCC, I think the EFCC is much more concerned around corruption and much more concerned about the enforcement of actions against corruption happening in whatever front, particularly in the public sector. And you dare say you've raised the situation with the previous government. Those areas are the remit of the EFCC. When it comes to the enforcement of actions, as I say, against virtual asset service providers, the Securities and Exchange Commission has full charge of that area. And this is where I also think that there needs to be, in Nigeria as well as other African countries, there needs to be a clarity and a consistency of the policy around who regulates what, and who is in charge of what, for us to avoid this overlap, if you like, of regulatory actions and enforcement actions against particularly market players in this space. I think the Securities and Exchange Commission is well equipped to do this job.
Okay, so while we are not able to categorically lay claims to culpability on the part of Tigran Gambaryan, as it were, as an entity, of course, the Nigerian government has come out to say that there are evidences to prove, sufficient evidence to prove that Binance now, as a corporate entity, is culpable in the allegations around, money laundering, as it were. So they've said that they are going to continue to probe this case with Binance, even if they have to let Gambaryan go. So we just wait and see what the outcome would be. We don't know if it's going to be next few weeks, next few months, or years, but then it's a pressing issue that we'll continue to keep our tabs on. Professor Iwa Salami, Director, Center of FinTech, University of East London. It was nice talking to you. Thank you so much for your time.
Thank you for having me.
It's a pleasure. That's the end of today's edition of Business Edge. Do not forget that you can visit our social media handle at News Central TV. And of course, our website is www.newscentral.africa. And App Store and Play Store, you can download our mobile app right there and check us up on YouTube. My name is Lekon Obanjo. Enjoy the rest of your day.